Good afternoon, everybody. This is third-party ag liens. You're not as secure as you may think you are. Welcome to the program. I'm Brad Kruse, and I have with me Emily Staudacher, and we're going to be going through a number of things today. But we thought this was a excellent opportunity and a good time to review ag liens, what they are, what their priorities are, especially in the current economic climate. What we have is Chapter 12 bankruptcies are up. We're seeing more ag loans that are in distress, more ag loans that are under collateralized, and just altogether some general concern about the ag lending environment. So we think it's a good time for people to be aware of the principles and characteristics and some of the ins and outs of ag liens in Iowa. So in this backdrop, it might be good to understand just as a first principle that ag liens arise by nature in virtue of statute. They're statutory liens that automatically attach. And this is in sharp contrast to the way liens normally arise in the typical lending situation. In the typical lending situation, a security interest is granted pursuant typically to a security agreement that provides the lender with a lien on various collateral described in the security agreement. And at that point, the lien is said to attach to the collateral. So the attachment occurs when a security agreement provides the secured lender with a lien. And the next step in that situation is for the lender to perfect the security interest by filing a UCC statement, UCC financing statement. Agricultural liens are a little bit different. The lien attaches automatically upon the occurrence of a certain event. For example, like in a landlord's lien, when a lease is entered into, or in an agricultural supply dealer's lien, when agricultural supplies are furnished. The lien attaches at that point. That's not to say, though, that perfection still isn't important, and there are steps to that that still have to be taken in the situation of an agricultural lien. Perfection must still occur, even though the lien is created by statute automatically. We're going to talk about landlord's liens today. That's Iowa Code Section 570. We're going to go over agricultural supply dealers liens. That's Iowa Code Section 570A. We're going to talk about harvesters liens, Iowa Code Section 571. Custom cattle feedlot liens, Iowa Code 579A. Commodity production contract liens, Iowa Code Section 579B. Lien for services on animals, Iowa Code 580, and veterinarians liens, Iowa Code 581. Those are the Iowa agricultural liens that are out there and their corresponding statutory reference. So that's what we're going to be going over today, and we'll jump into it in a moment. The key thing to remember about all agricultural liens is that they automatically attach to farm products, farm collateral, which include crops and livestock, in order to secure the payment for the goods and services furnished to a farm operator. And the reason and the policy behind the agricultural liens are to encourage vendors of farm supplies and farm services to provide those supplies and services to farmers and encourage them to do so even if there isn't a formal security agreement or lender relationship. So let's jump right into landlord's liens. That's Iowa Code Section 570. That provision provides that a landlord shall have a lien for the rent upon all crops grown upon the leased premises and upon any other personal property of the tenant which has been used or kept thereon during the term which is not exempt from execution. So a landlord's lien is a lien for rent on all crops grown on the leased premises and on other personal property that's kept thereon. It automatically attaches to any farm products that are grown on the land, and it has a special priority ahead of previously perfected security interests in statutory liens. And this priority comes ahead of banks, and it also comes ahead of ag supply dealers, who may also have liens as well. We'll get into priorities in a little bit, but I'm gonna touch on them briefly as we go. Now, the key to perfecting, and again, we talked about the attachment, and the difference between attachment and perfection. So it automatically attaches as soon as the lease on the farm ground begins. So there's the attachment component. But in order to to perfect the security interest, the landlord has to file a UCC-1 either at the time of taking possession or within 20 days of taking possession to be able to have that perfection and be able to maintain that lien ahead of any bank or financial institution that has a lien on the similar product, farm products. The landlord's lien continues for 1 year after the rent is due, or for 6 months after the end of the lease, whichever comes first. It's so one way to look at it is that it's only available at the time the tenant takes possession of the property and within 20 days thereafter. If the UCC is not filed in that time frame, then the priority as to other lien holders such as banks, financial institutions is lost. A couple of things I would point out. I will try not to get down too much into the weeds here on this, but a couple of things that I would note. Iowa farm lease law indicates that the termination date for farm tenancies is March 1st of the year that the lease terminates, and that's under Iowa Code Section 562.5. And because most farm leases begin on March 1st and the tenant takes possession on that date, a financing statement to perfect a landlord's lien in farm products would typically have to be filed by March 20th of that year in which the lease begins in order to perfect the security interest. Another point to make is that under Iowa farm lease law, that if a farm lease continues past a 1 year, it could be a multiple year lease, or if it even if the lease is only a year long and the tenant continues in possession of the property on a holdover basis after that, the Iowa farm lease law indicates that situation, in that situation, the lease would continue from year to year on a year-to-year basis. So it's a little unclear under those provisions as to whether or not an additional perfection of a security interest would need to be filed, or if an additional UCC would need to be filed in that situation. For those would-be landlords, or those landlords out there that are trying to obtain a security interest, the advice would be to file a UCC each year even if the lease is a multi-year lease, either because the term of the lease just is a 5-year lease, say, or even if it goes into a holdover status and it's going year to year, the recommendation would be to file a new UCC each time, or each year, in order to preserve it. And likewise, if a bank is in a situation where that hasn't been a yearly UCC1 hasn't been filed by the landlord, that's potentially an area to challenge, and as the law is a little bit unsettled there. There is some new law, well, not new law, but there is some law out there that indicates that the landlord's lien attaches to proceeds. There was some confusion on that back in the 80s, and I'll try to point out as we go through some areas that maybe have changed. There's been a fair number of developments since about 2011. So if the last time you had an issue was, in the economic downturn of 2007, 2008, 2009, kind of that period, it would be good to double check the status of some things, because some things have changed significantly, and I'll try to point those out as we go through. One of them is that the lien created, the landlord's lien created under 570.1 extends to proceeds of crops grown on leased premises. And that holding that was from the Iowa Supreme Court back in the late 80s was also extended to the proceeds of the sale of hogs as well. So a little bit of kind of an update to that situation. I'm going to jump go to the next slide. I'm going to jump forward from landlord's liens. We're going to go over and talk about agricultural supply dealers' liens. And that those liens arise under Iowa Code Section 570A.3. The agricultural supply dealer's lien is a lien for the retail cost of the agricultural supply, which does include labor provided. It applies to all crops and all livestock, although there is a little bit of a differentiation between crops and livestock when we get to the certification requirements and when we get to the priorities, and I'll get to those in a minute. But as with the other agricultural liens, in order to perfect the lien that again attaches at the time that the agricultural supply is provided, the supplier must file a UCC1 financing statement within 31 days after the initial purchase, and I've added the language "and after any subsequent deliveries." Now, there again is another change in the law that's fairly recent. That is from a 2016 Iowa Supreme Court case. So again, if you're a lender or a party that has not really dealt with any issues with respect to ag liens in the last several years, there have been some changes. There was a split of authority in the courts as to whether a agricultural supply dealer was required to file a new UCC each time goods were delivered, or as to whether they could simply rely on the UCC that was filed at the time of initial delivery, and that they didn't maybe have to file separate UCC1s each time goods were delivered. Well, it may not. You don't probably have to file each time that goods are delivered, but certainly if 31 days goes by and new goods are delivered outside that initial 31-day period, the Supreme Court has clarified that in order to perfect the lien and maintain the priority that you get with the agricultural supply dealer's lien, the supplier has to file a UCC1 financing statement, within 31 days after the initial purchase, and that would cover any subsequent deliveries. So there's a new development from 2016 that clarified an area that was somewhat unsettled before. The agricultural supply dealer's lien has equal priority with prior perfected bank liens, and it also will cover the priorities with other, but it is lesser in priority to a landlord's lien and to a harvester's lien. Now, I got to qualify that equal priority because there's a certification requirement that must be complied with for agricultural supply dealers' liens, and that certification requirement basically requires that in order to enforce a lien, the supplier must provide a certified request to lenders who are on record of having pre-existing security interests in the crops or livestock at issue, and that certified request has to indicate the amount of the purchase, the terms of the sale, and a waiver of confidentiality signed by the farmer. And after receiving the certified request, the lender is required within 4 days to issue to the supply dealer a memo indicating whether or not that the farmer or purchaser of the supply has sufficient net worth in order to ensure payment. If the lender states that the farmer has sufficient worth in the line of credit, the memo essentially operates as a letter of credit for a period of 30 days when the final payment is due. On the other hand, if the memo issued by the lender states that the farmer doesn't have sufficient worth or line of credit, then the lender maintains its priority with respect to that particular lien, and that really makes sense. So essentially, what's happening is just simply that the policy goal is that to try to discourage an agricultural supply dealer from just haphazardly, without doing much due diligence, just issuing, abusing its priority status by lending, providing credit to a farmer who is maybe not in a good position to receive that. And so the policy is that in that situation, if the ag supply dealer doesn't at least make inquiry, then they shouldn't be able to hop over the position of the bank with respect to the ag supply dealer's lien. Now, if that wasn't, hopefully that wasn't confusing, but another nuance to that is that now that certification only applies to agricultural supply dealers' liens on crops. And as you might remember moments ago, I mentioned that the lien applies to crops and to livestock. But the certification requirement has been held by the Iowa Supreme Court to only apply to crops, not to livestock. Livestock producers have a special position vis-a-vis the agricultural supply dealers' lien. They are able to maintain their priority position and maintain their agricultural supply dealers' lien as to supplies rendered to livestock, even if they do not comply with the certification requirements. And that was a Iowa Supreme Court case, the case of Oyens Feed and Supply v. Prime Bank. There's a series of those Oyens cases, and that was a case from back in 2011. So again, if you haven't been involved in one of these in the last few years, that's a new big change that was clarified by the Iowa Supreme Court. So in that situation, in the situation, where livestock is involved, note the certification requirement does not have to be complied with by the agricultural supply dealer in order for that supply dealer to maintain its lien and its lien priority. So. And all that language comes out, a lot of that language comes out of the certification language comes out of Iowa Code Section 570A.2. We were happy to help you if there's any confusion in that regard. You can certainly, if you dare, endeavor to read the statute. It's all in 570A.2, but we're happy to provide any clarification on those requirements if necessary. I mentioned the Oyens case, and it was quite an important case by the Iowa Supreme Court. Again, we can I'll give you the case site. That's 808 Northwest 2D 186 for any lawyers out there or any other parties that follow that kind of thing or would like to read it. And that's an Iowa Supreme Court case from 2011. That's the case that holds that the lien is does not, the certification requirements do not apply to livestock feed. So let me see here if there's one other case I wanted to point out that's kind of an important case. Another one is the case of In re Schley, and that was a court from the bankruptcy court for the Northern District of Iowa in 2014, and the court ruled there that an agricultural supply dealer's lien created pursuant to Iowa Code Section 570A, that if it was held that if the lien only applied to hogs themselves and not to the proceeds, the court held that would not make much sense, and that it would provide a little protection to the feed supplier and would discourage feed suppliers from working with troubled farmers. So the import of that case was to clarify that in an agricultural supply dealer lien, not only does the lien attach to the hogs themselves or the cattle themselves, but it would also apply to the proceeds of the sale of such hogs or cattle if they were essentially sold. And the court reasoned, and I think quite correctly, that if the lien didn't actually attach to the proceeds, there wouldn't be much, it would be pretty hollow comfort and not much protection to an agricultural supply dealer if to have a lien, but only to see that lien washed away if the farmer sold the hogs, sold the cattle, what have you. So there was a clarification of that. That was a 2014 case, again a slightly new development. So if you were had an issue come up in the past and there was some maybe some confusion or question of whether the lien, the agricultural supply dealer's lien attached to the proceeds of livestock, that was clarified in that case. Then I'm going to flip over to harvester's lien, which will be the last of the liens that I cover before Emily takes you through the remaining liens. The harvester's lien, that arises, and that would be next on the next slide. Harvester's lien, Iowa Code Section 571.1. Harvester's lien is a lien for the value of harvesting services that applies to crops harvested by the harvester. It becomes effective and attaches at the time that the services are rendered. Once again, as with the other liens, even though it attaches, in order to perfect the lien and preserve the priority, a harvester must file a UCC-1 financing statement within 10 days after the last date that services were rendered. Now, I can tell you as a little aside, sometimes that can be quite a sticky factual situation if there's a lien dispute or a priority dispute and a dispute under whether the underlying lien was perfected, because it sometimes is not clear exactly when the last date that services were rendered. Courts have generally been fairly liberal on that, but it's often very difficult to prove either by one side or the other in a dispute, in such a dispute, as to when the last date the services were rendered. Is it the last day that the equipment was taken off? Did the harvester's mere presence on the site, even though no work was done, did that constitute services being rendered? Those are some issues that can kind of arise in that. It can get very sticky as to when the last 10 days were. And again, it's just very difficult to prove when the harvester was last there. But that's just something to be aware of. The harvester's lien does have priority over a conflicting security interest in the harvested crops, regardless of when that security interest was perfected. And also, it's as I briefly touched on before, and a harvester's lien has priority over a conflicting landlord's lien as well. So, which is probably a pretty good segue into the next slide, which is lien priorities, which can be a little bit murky and somewhat intricate. The ag supply dealer's lien has equal priority to a lien or security interest created prior to the time of perfection. For example, it's equal to a bank security interest in collateral for an operating loan. Now, a landlord's lien has priority, as I mentioned before, over a conflicting ag supply dealer's lien. And a harvester's lien also has priority over a conflicting ag supply dealer's lien. Now, you see that I've noted the super priority down there, and that basically, I think we've probably covered that, but that simply refers to the super priority that's given an agricultural feed dealer in livestock. That's a separate animal. They have almost a better priority than a similar agricultural supply dealer lien on crops. That one, it has the ag supply dealer lien in livestock has priority over an earlier perfected lien or security interest to the extent of the difference between the acquisition price of the livestock and the fair market value price of the livestock at the time that the lien attaches, or the sale price of the livestock, whichever is greater. And once again, a new development by the Supreme Court, again, was in one of the Liens cases. The Iowa Supreme Court fairly recently indicated that in a farrow to finish operation, the acquisition price of the hogs would essentially be zero. That's any farrow to finish operation. So, and then last bullet point, the agricultural feed dealer lien in livestock, as I've said, is special over the earlier lien or security interest to the extent of the difference between the acquisition price of the livestock and the fair market price of the livestock at the time the lien attaches to the sale price of the livestock, whichever is greater. I know I said that twice, but you almost have to read it twice or look at that twice and think about it a couple of times because it's drafted sort of oddly in the statute. But that's it's worth noting that, and that can be, again, that's one of those situations that can be very factual, somewhat factual intensive in terms of the calculation as to the amount of the lien. I think we've next slide, I've got agricultural supply dealers lien, the certified request process. I think we've covered that pretty well, but just to reinforce, ag supply dealers must provide a certified request to other lenders who have provided operating liens to the farmer in order to enforce their ag supply dealers' liens. Again, after receiving a certified request, the lender within 4 business days must issue a memo to the dealer stating whether or not the farmer has sufficient net worth or line of credit to make the payment. If the lender says yes, the memo operates as a letter of credit. Let's just real briefly look at it in the opposite way. If the lender does not respond within 4 business days at all, then the ag supply dealer's lien is going to be given priority over the lender's lien. On the other hand, if the lender responds within the 4 days and issues, a memo to the supply dealer indicating that the farmer does not have sufficient credit, then the lender will be able to maintain its lien position vis-a-vis the ag supply dealer's lien. And with that, I'm going to turn it over to Emily, who's going to do a great job of talking about the rest of the Iowa ag liens and give some very, very good real-world examples of things.
Thanks, Brad. First, I'm going to start with the custom cattle feedlot lien. A custom cattle feedlot operator has a non-possessory lien on cattle and identifiable cash proceeds for the amount of the cost for the care and feeding of cattle. This lien becomes effective when the cattle arrive at the feedlot, and it continues for 1 year after the cattle leave the feedlot. Just as most of the ag liens are, it is perfected by filing a financing statement with the Secretary of State's office within 20 days of the arrival of the cattle at the feedlot. And it is a priority lien with the exception of a perfected veterinarian's lien. A perfected custom cattle feedlot lien has priority over all the other statutory liens and Article 9 security interests. And this is regardless of when they are perfected. Unlike the landlord's lien, you do not need to provide a statement on the financing statement indicating that it is a custom cattle feedlot lien. As I will discuss in a little bit more detail, this is beneficial because if you're a custom cattle feedlot operator, you could potentially use this lien or the next one I'm going to talk about, which is the commodity production contract lien. In order to enforce a custom cattle feedlot lien, there are 2 separate scenarios. One is that in which the cattle are located at the feedlot still, and this is the same as other agricultural liens following that statutory process. If, however, the cattle have already left the feedlot, the operator may enforce the lien by commencing an action at law for the amount of the lien by doing either one of 2 things. The holder of it can go against the holder of the identifiable cash proceeds from the sale of the cattle, or if the cattle went to a processing plant, the processor who has purchased the cattle within 3 days after the cattle have left the custom cattle feedlot. So if a feedlot operator is looking to enforce a lien, they must be diligent in monitoring their collateral, because if it goes to the processor, they only have 3 days to commence that action. As I briefly touched on, custom cattle feedlot operator may file and enforce a lien under either this section or the commodity production contract lien. One thing that cattle feedlot operators should be aware of, however, is that if they were to loan money to a producer to purchase the cattle that are going to be fed in the lot, that is not an automatic lien like the feedlot lien. The feedlot lien only applies to the feed and services that were rendered in that feedlot, not the purchase price of the cattle. So if this is a scenario that occurs, a feedlot operator would need to get a standard security agreement put into place and file a financing statement under Article 9 as a typical lender would in that situation. The commodity production contract lien is when a producer is feeding another person's livestock, not including poultry, or raising another person's crop on the producer's farm. And the purpose must be for food, animal feed, fiber, or oil. If the livestock or crop is sold by the contractor, the lien can be on the cash proceeds from that sale, and the cash held by the contractor shall be deemed to be cash proceeds from the sale, regardless of whether it is identifiable or not. If the livestock is slaughtered or the crop is processed by the contractor, the lien shall be on the property of the contractor that may be subject to a security interest as provided in Article 9, which is the standard security interest code chapter. The lien is effective when the livestock arrive at the farm or when the crop is planted, and it continues for 1 year after that time. Again, it's perfected by filing a financing statement within 45 days. So one thing to point out here is if you are a cattle feedlot operator and you missed your 20-day deadline with that, under that code section, you can still file a financing statement and keep your super priority as long as it's within that 45 days, or as the next bullet point says, the 180 days if the livestock continuously arrive, meaning more than or a period of 30 days, there's multiple arrivals. With the exception of a perfected veterinarian's lien, a perfected commodity production contract lien has priority over other statutory liens in Article 9 security interests, regardless of when they are perfected. And again, this ag lien does not require an express statement on the financing statement. So going back to the cattle feedlot operator, if that's your business, then realistically, when you file the financing statement, it could be either a Chapter 579A or 579B ag lien. When enforcing, in order to enforce a commodity production contract lien, if it is before the commodity leaves the authority of the contract producer may enforce a lien created in that section, just as they would any other agricultural lien as provided in the Article 9, which is the security interest part of the Iowa Code. After the commodity is no longer under the authority of the contract producer, the producer may enforce a lien provided in Article 9, Part 6. Waivers of right provided by the Chapter of Board, so you can't waive your right to this lien. with a bank. And as I had already mentioned, a custom cattle and feedlot operator might file and enforce a lien under 579A or B, but not both. So when you really only need to file one financing statement if you're a cattle feedlot operator, but you can only enforce under either chapter. I already kind of mentioned about if a cattle feedlot operator misses the 20-day perfection period, they get a second shot at the apple, so to speak, by perfecting under this chapter. The veterinarian's lien is for the services provided by a veterinarian in treating a livestock, and it's only for the cost, the actual cost of any product used or services rendered. So in theory, the amount of this lien would be relatively small. It becomes effective when the treatment occurs, and it is perfected by filing a financing statement within 60 days after the treatment. And it has priority over conflicting security interests or liens regardless of when they're perfected, enforced by the same code chapter as the other ag liens, and there is no express statement on the financing statement required. I don't have a slide for it, but there is one other statutory lien that to be aware of, and that is for the services of animals, and that would constitute services for stud fees or things of that nature. And those become automatically perfected as well. Just something to be aware of. Probably doesn't occur too often, but just something to be aware of that is out there as well. Okay, the next thing I want to discuss a little bit is the purchase money priority rules in agriculture, and these are not to be confused with the agricultural liens that we have been discussing for the presentation up until this point. These are what are referred to as security interests in Article 9, and they are the typical type of thing that a bank would see as far as their liens go. So these require a consensual agreement from the debtor to sign a security agreement, whereas everything up until this point was a unilateral non-consensual lien. This is a consensual lien. However, it also has super priority implications, so I wanted to discuss it in this presentation today. To obtain a purchase money super priority in equipment collateral, the creditor must satisfy two requirements. One, that the credit extended by the creditor must actually be used by the debtor to purchase the collateral. And two, the creditor must properly file a financing statement covering the collateral within 20 days of the date the debtor takes possession of the collateral. Another thing worth noting that in a priority dispute between two perfected purchase money creditors, a security interest in favor of a seller will take priority over a security interest in favor of a creditor who merely extended an enabling loan, meaning the loan which enabled the borrower to acquire the collateral. I bring this up because many bank loans or operating loans would be those enabling loans. So it's worth noting that a purchase money lien directly from a financing company for the purchase of equipment would take priority over those operating loans. And I have a couple of examples here just to further illustrate how that would work. So our first example is that on March 1st, bank extends a line of credit to farmer. Farmer grants bank a security interest in all equipment and farm products now owned or hereinafter acquired. Bank properly files a financing statement on March 10th with the financing statement containing blanket language. On October 1st, farmer approaches finance company to request a loan for the purchase of a combine. Finance Co. agrees to make the loan, and once the specific combine is identified for purchase, Finance Co. disperses the funds for the purchase directly to the equipment dealer. Farmer signs a security agreement granting Finance Co. a security interest in the combine. Farmer takes delivery of the combine on November 1st. On November 16th, Finance Company properly files a financing statement describing the combine by brand, model, and serial number. Farmer subsequently defaults on his obligations to bank and Finance Co. And the question is, who has priority in the combine? The answer is Finance Co. because it extended the purchase money used to acquire the combine and properly filed a financing statement covering the combine within the 20 days after farmer received possession. A second example to be aware of is the one I have here. It's one in which ag lender extends a line of credit to farmer, and farmer grants ag lender a security interest in all inventory, equipment, and farm products now owned or hereinafter acquired. Ag lender properly files a financing statement on March 2nd with the financing statement containing blanket language. On July 1st, farmer then requests a new loan for a combine from the equipment dealer. After meeting with farmer and reviewing the documents, bank agrees to make the loan on that equipment. The bank disperses $180,000 directly to farmer, which is equal to 80% of the retail price of the combine. On that same date, farmer signs a security agreement granting bank a security interest in the combine. Then, on July 20th, farmer acquires the combine from the dealer. Instead of using all the funds provided by bank, farmer transfers several items of equipment to the dealer as trade-ins for the combine. After considering the traded equipment, then only $70,000 remained as the price for the combine. So then the farmer pays this amount to the dealer using the money loaned by the bank, that $180,000, and uses the rest of the loan to buy a bass boat, 2 jet skis, and an above-ground swimming pool. All this time, bank is unaware that much of the loan funds were used for purposes other than buying the combine and files its financing statement on July 30th. Then farmer defaults. The question then being, who has priority? Well, bank filed its financing statement within the window as it should have, but only $70,000 of the money loaned gets that purchase money security interest priority. Thus, bank has priority only on the $70,000, not the remaining $110,000 that they loaned out. So I think this example is a good demonstration of why, if you as a lender are in the market of these purchase money loans, it's a good idea to make the check directly payable to the equipment dealer or other entity that is selling the product. Then I just wanted to discuss, a couple of ways to protect yourself as a lien holder. When it comes to the ag supply dealer's lien, there's a few provisions that could be included that at least would help. And that would be, you could require that a producer list all their feed suppliers, require notice, subordination, or waiver of feed lien by producers' feed suppliers, require producer to provide monthly feed bills to the lender, or provide for the lender's ability to adjust the borrowing base if there are any unpaid feed bills. That comes up as a result of that Oyens case that Brad discussed earlier. In addition, it's essential that the perfection of an ag lien is maintained. Normally, for a security interest, it is governed by law where the debtor is located, but for ag liens, it is governed by law where the collateral is located. So, if ag lien collateral leaves the state, you should ensure that you perfect in that new state. Otherwise, the priority is lost during that time period. Additionally, and Brad touched on this, but if the collateral is sold, an ag lien continues on that collateral if it is sold, leased, licensed, exchanged, or disposed of in another way, unless the secured party authorized the disposition free of the lien. And but as Brad mentioned, it is disputed as to whether an ag lien attaches to the proceeds of collateral. So it is wise to get a consensual security agreement just to ensure that that doesn't become an issue. Okay, this is simply just a handy chart that I wanted to include. It is from the Iowa State University Center for Agricultural Law and Taxation. They have a lot of really great resources as well relating to other topics. So this is mostly just for your reference, but it is a very good summary of what we have discussed today. So I think in wrapping up my portion in this webinar today, I think that the examples that we've provided and the priorities created by these ag liens and purchase money security interests show that it is essential to evaluate your collateral position on a periodic basis. I would say obviously it depends how often you evaluate that depends on the creditor's position at the time. But it's worth noting that the best time to correct technical errors or deficiencies in loan files is at the first sign of distress. This is the point at which the lender has leverage and the debtor is often still willing to cooperate at this time as well. So, as we feel the walls kind of closing in on the ag industry, at least that seems to be the feeling right now, it's important to think about these things and evaluate your collateral position and take a look at your loan files. Our firm would certainly be able to assist you in loan files and help you to identify any possible issues. Each loan file is completely different, and it's to say exactly what to look for without knowing the contents of each loan file. But I think these should give you some things to look out for anyway. Sure. It looks like we had a question pop up, and the question says, what is the status on bank blanket UCC filing in regards to federal crop insurance proceeds? There was a district court case that concluded an entity with specific lien with the carrier took priority over the blanket lien position. I am unaware of this district court case, but now I'm very interested in it, and we'll take a look at it and get a more specific answer to your question. However, I think it's worth noting that farmers may assign cash payments to the bank with an assignment of payment, and the payments are considered general intangibles, and the crops are considered farm products. There is a specific form for the assignment of payment, and it is from the USDA. I believe it is form number CCC-36, and that's the assignment of payment. The bank must also have a security agreement covering the collateral and perfect by filing a UCC-1. So that financing statement the security agreement must cover those general intangibles for those cash payments. Let's see.
Yeah, and just to add to that, to the extent maybe that the question is seeking, like in the guidance in the priority context of an ag lien, as Emily noted, the security interest to which ag liens attach to is a pretty narrow universe of items, and they're just limited to farm products. In fact, they're just limited to the farm products which were supplied by the agricultural supply dealer or the services from a harvester and so forth. So it's just related to those specific farm products related to that land. Now, with a landlord's lien, it does encompass a little bit of an expanded world there, which would include personal property that the farmer brings on the land as well, and that's in the situation of a landlord's lien. But it's not to say that that an ag supply dealer or that an ag lien holder has like a blanket lien on all of the assets, farm assets that the farmer might have, such as equipment and, right to receive payments, general intangibles, and all of that. So again, I probably shouldn't say too much because I haven't read the case either, and we can take a look and respond and give our take on the impact of the case.
All right. With that, I think that concludes our webinar for the day. Thank you for attending, and please let us know if you have any additional questions or if we can help you out with anything in the future.